judiciary means the judges, the lawyers versus judges, and others associated with the judiciary. And speaking for myself, I can say that the best judgments came when there was good assistance from the lawyers. It is a privilege for me to be here this evening, delivering the Sailabala Pujari memorial lecture. She was not just an outstanding lawyer, the first woman lawyer of Western Orissa, but she was a multi-faceted personality, an outstanding woman, and on Indira bestowed. She was also a literature and a poet who wrote poems. In those days, it must have been extremely difficult for a woman to make a breakthrough, and she did it. She involved herself in human rights, in protecting the human rights of scavengers, manual scavengers, and other oppressed persons in society. Women have always faced some difficulty, and sitting here in the presence of the Advocate General, I feel very nostalgic because I'm reminded of Mrs. Sailabala Mukherjee, our beloved lady. I think she herself was a victim of gender bias, or else she would have made it to the judiciary. The loss was not hers, of course. The loss was that of the judiciary. And I still recollect that on 5th February 2002, the day I was elevated as a judge, Gopal, Mr. S.N. Mukherjee, the present Advocate General, he went to Delhi at that time. Again, Joloda, Mr. S.B. Mukherjee was a minister in Delhi. And the first thing we asked was, how is Indira looking on the bench? I wanted to go and visit her, but unfortunately, just 2 days later, on 7th February 2002, she suddenly passed away. Anyway, these are memories, but I think the vision of the Indian Constitution is an apt topic, considering the life and the contribution of Sailabala Pujari, and of course the role of the judiciary as well. I do hope that the students sitting here today will contribute to the justice delivery system in one way or the other. I hope some of you join the judiciary, and I see amongst you my successors in office in future. I may not be there to see you, but I'll be happy to join and contribute to the judiciary. The Indian Constitution, as you all know, is that basic document on which the pyramid of the Indian polity rests. We have a people-centric, egalitarian constitution. And since we are talking about women, I would also say it is a woman-friendly constitution, because all the rights are equally available to all including women, and there are provisions in Article 15, Sub-Article 3, for making special laws for women to set right along prejudice, gender prejudice that has prevailed. On 26 November 1949, the people of India have been resolved to constitute India into a sovereign democratic republic, adopted, enacted, and gave to themselves the lengthiest constitution in the world, consisting of 395 articles, divided into 22 parts. 2 more schedules were later added. The constitution underwent several amendments, which we need not discuss just now. The concept of a constitution in the name of the people, defining the powers of the different organs of the Indian polity and delineating the relationship between them and also between the government and the citizens, emanates from the principle that individuals have natural rights which are inherent and inalienable, which existed long before any written instrument like the Constitution was thought of. The government acquires its authority from the people, and that the purpose of government is to promote common good. The state emerged because of the advent of democracy and a limited government and the governance between citizens. The idea of an organized state was to maintain peace, law and order, for improvement of the people in general. A written constitution like ours empowers the citizens. It limits power and protects liberties. As Lord Acton had said, power corrupts, and absolute power corrupts absolutely. A written constitution like the Indian Constitution unfolds a vision and a goal, and chalks out the path for its realization. The preamble to the Constitution summarizes the aims and objects of the Constitution. The people of India, acting through their representatives in the Constituent Assembly, enacted, adopted, and gave to themselves the Constitution, which promises to secure to all justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote amongst all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. The preamble was amended by the 42nd Constitution Act, with effect from 1976. And then Sovereign Democratic Republic was amended to read Sovereign Socialist Secular Democratic Republic. And also, and integrity was added after unity. But these amendments didn't really make much change except to emphasize, because we have from the very inception had a socialist polity which believed in equalities, which believed in social equality, economic equality, political equality, and a secular constitution because it guaranteed freedom of faith, freedom of religion, so on and so forth. The vision of our constitution is to be found in its preamble and also in parts 3 and part 4 of the constitution, containing the fundamental rights and the directive principles of state policy. The fundamental values and principles on which our constitution is based are embodied in the preamble. The words used in the preamble of our constitution are some of the noblest words. They embody the highest values. The preamble is the key to the minds of the framers of the Indian Constitution, as observed by the Supreme Court in the Bannerjee case. However, Justice Gajendra Gakkar said that the preamble was not part of the Constitution. Also, it did not confer any substantial powers to the legislatures or other organs of the state. These must have their source in express or implied ground by substantive provisions of the Constitution. Now, observations actually hold good even today, except that the principles in the preamble are now accepted to constitute the basic elements and basic features of the Constitution, evolved later on in Keshavananda Bharti. Yes. And these basic elements and features were held to be unamendable. In Sajjan Singh versus the state of Rajasthan, Justice Madhurkar said that the preamble had the stamp of deep deliberation, was marked by precision, and the framers of the Constitution attached special significance to it. In Golaknath versus state of Punjab, Justice Hidayatullah observed that the preamble to the Constitution epitomized principles on which the government was to function. The preamble was the very soul of the Constitution. The scope of the fundamental rights guaranteed in Part 3 of the Constitution and the directive principles of state policy can be better understood in the light of the objectives enshrined in the preamble, as held by the Supreme Court in all of you will be able to help me out in that Mysore case of 1970, Bharti Chandra. Anyway, that is what the Supreme Court has held. I'll give the exact reference later. In Kesavananda Bharti versus State of Kerala, the majority referred to the Constituent Assembly debates, revised Justice Gajendra Gakkar's view, and held that the preamble was part of the Constitution, and that observations to the contrary in Bannerjee Union were not correct. The preamble, in fact, contained the basic features of the basic elements of the Constitution. Justice Sikri said that the legislative history of the preamble to the Constitution justified its intents. The preamble was not only very much part of the Constitution, but it was of extreme importance, and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. In Keshavananda Bharati, the majority held that any provision of the Constitution could be amended under Article 368, but within the broad contours of the preamble. The Supreme Court held that the inalienable basic elements of the Constitution could not be amended so as to alter them. The inalienable basic features of the Constitution were sought to be traced from the words of the preamble. So the preamble is now considered to be an inviolable part of the Constitution and assumes a special position as an aid to integrating the Constitution. In Bomai versus Union of India, Justice Ramaswamy said, the preamble of the Constitution is an integral part of the Constitution. Democratic form of government, federal structure, unity and integrity of the nation, secularism, social justice, and judicial review are basic features of the Constitution. To sum up, the Indian Constitution as it stands today, after the 42nd Amendment, envisages India as a sovereign, socialist, secular republic embedded in the values of justice, liberty, equality, fraternity, individual dignity, and national unity and integrity. The Constitution is egalitarian. The edifice of the Constitution is founded on the principle of absolute equality. The Constitution promises to secure to all the citizens of the country justice, liberty, equality, and to promote amongst all fraternity, ensuring the dignity of the individual and the unity and integrity of the nation. It recognizes the people as the repository of all power. Sovereignty, of course, is one of the most essential attributes of the state and connotes absolute power to take decisions as permitted by the Constitution, of course, without control from any internal or external authority. In Keshavananda Bharati, Justice Matthews said, the Republic of India was sovereign because it could make or unmake any decision with respect to itself without interference from outside. Socialism, of course, would mean elimination of inequality in status, income, and standards of living. After the insertion of socialist in the preamble, courts interpreting the Constitution would lead in favor of nationalization and state ownership of private company, equal pay for equal work, etc. And this has been done in cases pertaining to coal mines Nationalization Act. In the Vinaba Bill's case, and many other cases. But with the new economic policy of liberalization, there may be some clash or conflict with the word socialist, which has been incorporated in the preamble to the Constitution. Now we come to secularism. What is secularism? As per standard dictionaries, secularism means not spiritual, not concerned with religion, a system of belief which rejects all forms of religious faith and worship, or irreligious, so on and so forth. But very interestingly, the Constitution of Bangladesh, enacted in 1972, 4th November 1972, after Bangladesh became independent, starts with the words in the name of the Allah. It says that it's an Islamic state, but there is a provision which says it is a secular state with a guarantee of equality to Hindus, Buddhists, so on and so forth. So even secularism could have different meanings to different persons interpreting the expression. In the context of the Indian Constitution, the definition of secularism as attempted by Smith would perhaps be apt. He says, the secular state is a state which gives individual and corporate freedom of religion, is not constitutionally connected to any particular religion, nor does it seek to promote or interfere with religion. A secular state deals with an individual as a citizen, irrespective of his religion. In Siauddin Badhanuddin Bukhari versus Bijmohan Ramdas Mehra, Justice Beg said, the secular state arising above all differences of opinion attempts to secure the good of all its citizens, irrespective of their religious beliefs and practices. It is neutral in extending its benefits to citizens of all castes and creeds. So what is contemplated is happy harmony and synthesis between the different religions. In our country, anything pernicious and exploitative cannot be allowed to remain outside the control of law, only because it is paraded under the garb of religion. It is now well established that the state can interfere even with the secular affairs of religious institutions. And in many of the southern states, at least in Tamil Nadu, most of the temples are managed by the government through a specific department. The Hindu religious and charitable endowments department. In S.R. Bommai, the Supreme Court held that secularism was a basic feature of the Constitution and upheld the proclamation under 356, Article 356, imposing precedents known in the BJP states in the aftermath of the Babri Masjid demolition in 92-93. The judgment was delivered in 93 or 94. Now, democratic republic, of course, we have a presidential elected head of the state. The president is the elected head of the state. and the government is constituted by the people through a process of election. Now, what exactly is this justice which is talked about in the preamble? Justice means harmonization of interests between individuals and groups on the one hand, and the interests of the community. The preamble places justice first before liberty and equality itself. So it is the entire constitution is oriented towards securing justice. The principles which have been embodied in the preamble have been elaborated in the fundamental rights, where you have Articles 14 to Article 18, which are the equality clauses. Article 19, the freedom clause. Just a minute, don't turn it this side, papers will start flying. Unlike the kids of these days, do I use a computer and slow in using the computer. So after a while, when I find the time is running out, I switch on to scribbling and scribbling on pieces of paper. Then, of course, we have the right to life guaranteed under Article 21 of the Constitution of India. We have the right against exploitation, right against being trafficked, the right to freedom of religion, the right of minorities to establish educational institutions of their choice, and so on and so forth. Dr. Ambedkar had, in the context of the Constitution, in course of the debates in the Constituent Assembly, remarked something to the effect that even a bad constitution can be a good constitution if the people who are responsible for operation of the Constitution are good. And even a good constitution can become a bad constitution if the people who are responsible for the operation of the Constitution are incompetent. Now, here comes in the role of the judiciary. For a healthy democracy, we must have a strong, independent, impartial, and well-organized judiciary. An independent, strong judiciary prevents the arbitrary exercise of governmental authority. It also guards the rights of citizens. In our country, our judiciary is said to be the guardian of the Constitution, protector of the Constitution, so on and so forth. As we all know, one of the characteristic features of several constitutional systems in the world and also of our Constitution is the doctrine of separation of powers. This doctrine envisages demarcation and distribution of the powers of the legislature, the executive, and the judiciary. I need not go to the history, which dates back to long ago because of the paucity of time. But it would be apt to quote from Montesquieu's Spirit of Laws. Montesquieu said, when the legislature and the executive powers are united in the same person or in the same magistrates or body, there can be no liberty. Again, there is no liberty if the judicial power is not separated from the legislative and executive powers. Were it joined with the legislative power, the life and liberty of the subject would be exposed to arbitrary control, for the judge would then be the legislator. Were it joined with the executive power, the judge might behave with violence and oppression. This would be an end of everything if the same man or the same body were to exercise the three powers. In India, the demand for separation of the judiciary from the executive was a reaction to the judiciary, which combined two functions to suppress the Indian national movement. Raja Ram Mohan Roy, Dadabhai Naoroji, and others spearheaded the cause of separation, and associations were formed in Bengal, Bombay, and Madras. The movement gained momentum with the spread of education. In 18th Congress, adopted a resolution to take up the matter in a serious way. Public opinion about separation was so strong that the Constituent Assembly had to adopt the doctrine of separation of powers. So Dr. Ambedkar proposed a new Article 39A to the draft Constitution, which later became Article 50, which is part of the Directive Principles of State Policy. After the enforcement of the Constitution, the role of the judiciary has undergone a change. We have Article 32 incorporated in the Constitution, under which the right to approach the Supreme Court in case of violation of a fundamental right is in itself a fundamental right. The High Courts are clothed with wide powers under Article 226 of the Constitution of India to prevent breach of fundamental rights, legal rights, or other forms of arbitrariness. The constitutional courts, the High Courts, and the Supreme Court are the interpreters of the Constitution. They are the protectors of fundamental and other constitutional rights. Although many textbooks refer to the High Courts and the Supreme Court as the constitutional courts, I personally feel that all courts are constitutional courts because they owe their existence to provisions in the Constitution of India. And much contrary to what is thought, even the district courts may be required to interpret constitutional provisions in the course of hearing proceedings. Now, with powers of judicial review, the courts have been interpreting various provisions of the Constitution of India. A comparatively recent development in the judicial field is the emergence of what is criticized sometimes as judicial activism. The word activism is derived from the word activity. The word active means involved in something. Its antonym would be inert, inactive, tardy, lethargic. Activity is a state of things happening. Economic activity. We refer to economic activity where there is a lot of business going on. We talk of political activity. Activist would mean a person who works for a cause. And judges do work for the cause of justice, to secure justice in accordance with the Constitution, as per their interpretation of the Constitution. The judiciary cannot afford to be lethargic or inactive. It is expected to be active. Innovation and change for the better is always welcome. Of course, the judiciary should take care to ensure that it doesn't exceed the limits and enter into what is described as judicial overreach. It cannot take up administration altogether, but it should definitely be active. To quote Justice P.N. Bharavati, judicial activism is nothing but another form of constitutionalism, which is concerned with the substantivization of social justice. It tries to free the judiciary from the constraints of traditional judicial processes in the interest of social justice and calls for a more dynamic interpretation of the social values enshrined in the Constitution. Considering the lexical and common reasoning of activism, every judge is or should be an activist. To quote Justice Krishna Iyer, every judge is an activist, either on the forward gear or on the reverse gear. Judicial activism is something which is not totally new. Way back in the 90s, in the case of an undertried who could not afford a lawyer, the question was whether the court could decide the case by perusing the papers. Justice Mahmood held that the case could be said to have been heard if someone spoke. Now, this activity of the judiciary can be of two types, either in support of legislature or executive action, or in opposition to them. However, it is the activity in opposition to legislature or executive policy decisions which is generally criticized as judicial activism. In my view, in a sense, judicial activism is the rendering of decisions which are in keeping with contemporary thought. Judicial activism secures justice, the liberties, equality, fraternity, as stated in the preamble and elaborated in parts 3 and 4 and other parts of the Constitution. Now, please tell me when I have to stop. How much more time do I have? 10 minutes. Okay. I shall sum up in 10 minutes. In the recent past, we have had relatively recent past, I must say. It may be recent for old fogies like me, but not so recent for those of you sitting before me. The other genre of litigations is the public interest litigations, which have emerged. Now, where the rights of a citizen or a group of citizens, or a group of persons, I should say, is breached, and the person has no access to court, then any person can file a public interest litigation. The courts are liberal about the locus standi. But of course, even in a public interest litigation, the courts have to proceed in accordance with law. Now we quickly look at what the judiciary has been doing and how the judiciary has been interpreting the Constitution from the inception till today. I will be very brief. I'll just refer to 2 or 3 of the major judgments. In the initial days, there was not much conflict. The conflicts were restricted to the right to property because attempts were being made by the government to introduce land reforms. There were disputes with regard to compensation. The laws were challenged on the ground of inadequacy of the compensation. And the courts had been interpreting the Constitution, constitutional provisions, in some cases granting relief, but holding that the provisions were not amenable to challenge. The challenge to the provisions were rejected in most cases. So we have the case of Kanishwar Singh, followed by Sajjan Singh. In the case of Bannerjee, however, the Supreme Court said the compensation cannot be illusory. But the amendment was nevertheless not interfered with. The trouble started with Golaknath in 1967, when the Supreme Court held that the fundamental rights could not be amended. Then came Kesavananda Bharati, which reversed Goraknath, but introduced the principle of basic teachers which would remain unamended. We also see a positive change in the view of the Supreme Court. In A.K. Gopalan, in the case of A.K. Gopalan, Supreme Court was of the view that Section 21 only gave protection against executive arbitrariness. The arbitrariness of a legal enactment could not be questioned. But in the Maneka Gandhi case, the Supreme Court took an altogether different view. One of the areas where Supreme Court has, and also the High Courts, have exercised their power of interpretation is in the field of Article 21 of the Constitution of India, which reads, no person shall be deprived of his life or personal liberty except in accordance with procedure established by law. Today, that provision, if that provision were to be interpreted literally, it would just mean that a person cannot be deprived of his life, his physical life, or his personal liberty, except by recourse to a law enacted by legislature. But that provision has widely been interpreted by the Supreme Court to mean that the right under Article 21 means the right to live. The right to live includes the right to live with dignity. It includes the right to shelter. It includes the right to health care. It includes the right to a clean environment. It includes the right to speedy trial. It includes the right to fair trial. You name the human right, and you will find that there is a judgment of court which says that it is part of Article 21. And then, of course, more recently, we have judgments upholding the right of privacy as a fundamental right. The adultery provision has been struck down in Joseph Shine as discriminatory because it discriminates between the man and the woman. The wife is treated differently from the husband. Then Article 377 has been struck down. Many women commissioned officers, in the case of Babila Punia, the Supreme Court held that they would be entitled to appointment, even the permanent commissioner. So if there is a healthy tradition, we can give meaningful effect to the constitutional provisions. Just 2 minutes. It's just pages. To quote S.P. Sathe from his book, Judicial Activism in India, Transgressing Borders and Enforcing Limits. Judicial activism is not an aberration. It is an essential aspect of the dynamics of a constitutional world. It is a counter-majoritarian check on democracy. However, judicial activism does not mean governance by the judiciary. It must function within the limits of judicial processes. Within those limits, it may either uphold and legitimize the action of the other organs of the state and strike down their action. We still have a long way to go, but I think we have made a good start, and we can hope that we will be able to achieve the objects of the Constitution and also our future. Thank you.